I want to turn to our special guest in the studio, criminal defense attorney Michael Bixon. Michael, thank you for coming back. It's always a pleasure to have you here. Let's talk about what we heard already. Very powerful start to that closing argument by Dan Owens. Your thoughts in general on what we've seen so far?
So as far as the closing, I thought that in the beginning of it, at least, and it's still going on, so far it's very visual, very visceral, and it started off with a really big bang. Towards the last maybe 30, 40 minutes or so, maybe gone a little bit lengthy. It's hard to pay attention for jurors when you're sitting there, and especially on such a long case, but when you hear the same argument over and over and over, it gets a little bit repetitive. But I think he started out great. It did slow down a little bit. I think it's great that they're taking a break in the courtroom for the DA right now.
Right. And it's tough. I think the jury definitely deserves a break. That's a long time to be sitting there. And I think he's got to watch, because you don't want to lose momentum as an advocate. And I felt like he came out with such a bang. I thought, wow, I'm sitting here watching him, very impressed, using powerful language, powerful words, saying brazen, vile, despicable crimes, saying he's a sexual predator. He said, he took something from all of these women, and now you know what he's gotten. Kind of wrapping things up together, hearkening back to his opening statements where he said Kellen Winslow II was someone who took what didn't belong to him. And today, it's like he really wrapped it up, saying he was motivated to steal. I mean, called it, deviant, perverse, all of that. But now I feel like he's starting to lose some momentum because he's going into the elements and he's taking quite a long time. Your thoughts on whether that's an effective way to go about this?
Again, I thought he started off great. One of my favorite lines that he said was he threw them aside like trash. And for me, that just presented such a strong image.
Yes.
After that, though, and again, it's hard because you do have to talk about the law, and you have to talk about how the facts fit into the law. And to try to make that captivating and interesting, it's very difficult because it can be a little dry. But at the very least, he did start off with a strong start.
Yes.
Again, going through the law and how the facts apply to it, it did get a little slow. But we'll see how he finishes, and hopefully for him, it does pick back up a little.
Right, and there was an objection too by defense counsel, and that is tough. It's it's one of those things I was always taught. Don't object unless you absolutely have to, just out of deference and respect to the other advocate. And that way, it was such a minor thing.
I don't know, honestly. I actually agreed with the defense in terms of why they objected. And the objection was when he had said that he went home to his kids and wife after committing the crime. And those facts weren't in evidence, and it does paint a very strong picture to the jurors, and it can be very prejudicial. So I think for the defense, it was very important to point out to the jurors, at the very least, that we didn't hear anything about that. Even if the judge overruled it, which I'm not, and again, I understand that, there is this very strong argument about deference to opposing counsel when they're doing the closing arguments. But I think it's very important to them that they put their client first.
Gotcha.
And that, they make sure that the jurors know, we didn't hear anything about that.
Appreciate that, Michael. So great to have your thoughts and expertise. We need to take another break here on Court TV Live. We'll take you back in the courtroom right after this. Don't go away.
3 times faster than typical DSL. Get Viasat now and we'll guarantee your price for 2 full years. Everyone watching this commercial can now get super fast internet. Call now and get the perfect plan for you and your family. Plus, you get free standard installation that's fast and easy. Go to getviasat.com or call 1-888-674-0576 to sign up today, or visit your local Viasat retailer. Viasat, fast for all, is here.
Mom, thank God you're gonna be okay.
So relieved. But you both should know when my time comes, I have a final expense policy with Senior Care USA.
If you're over 50, call Senior Care USA now to learn more about final expense insurance plans.
When I called, the quote was free, and there was no pressure. Oh, so glad you'll be taken care of.
Call 1-800-258-6330. That's 1-800-258-6330.
Every woman wants beautiful brows, so we tweeze, we thread, and we rip. But now there's Flawless Brows from Finishing Touch, the new gold standard and first precision hair remover that instantly and painlessly sweeps away unwanted hair for stunningly beautiful brows. Hold it like a pencil, use it like an eraser.
I see a hair that I don't want and I'm able to erase it.
Because inside Flawless Brows precision hair removal tip is the finest engineered technology that erases unwanted hair with micro precision, perfectly balanced for perfect control between the brows, above, below, even toward the hairline.
I have very sensitive skin, so Flawless Brows is perfect for me because it's so gentle and it's so precise. It's not going to take more hair than I'm targeting.
And with an 18-karat gold-plated head, it's hypoallergenic and gentle on all skin types.
This was just so easy, so painless. It just erases the hair away.
Flawless Brows is the fastest, easiest, pain-free way to have beautiful brows every day, guaranteed.
One of my favorite things is I don't have to wait for the hair to grow out like you do with waxing.
It's a solution to an otherwise daily battle. I just see it and take it right off.
A built-in LED light makes it easy to see and erase unwanted hair. Discreet and portable, so you can use it anytime, anywhere.
I can do it myself whenever I want. For quick touch-ups, it's perfect.
Dermatologist approved, Flawless Brows is precision hair removal that's gentle and safe to the touch.
It's painless, easy to control, fast to use, super safe, and it's so pretty. I mean, it's perfect.
Call 1-800-448-0364 or go to getflawlessbrows.com and get yours for only $19.99 with a 60-day money-back guarantee. Order right now and get free shipping.
It just erases the hair away.
Flawless Brows.
Welcome back to Court TV Live, your front row seat to justice. I'm Julie Grant. Thank you so much for being with us. It is a huge day in the case of the state of California versus former NFL star Kellen Winslow II. Closing arguments are underway. The prosecution began delivering their closing argument at just a few minutes after 9 o'clock out west. The jury is on a 10-minute break right now. Deputy District Attorney Dan Owens still has not finished his closing argument, but the judge allowed for a break to give the jury some time to stretch. What we want to do now is take you outside the courthouse where we find Court TV's legal correspondent Chanley Painter to find out what the members of the jury were doing as they were watching that opening statement. Chanley.
Hey, good morning, Julie. It has been a jammed-packed courtroom for closing arguments this morning. As the jury filed in and took their seats, the judge gave Dan Owens the floor. He stood up and almost waited on purpose, a moment of silence, if you will, to really grasp the attention of the jury, because they did. They sat up in their chairs, they looked at Dan Owens, and he captured their attention in his introduction and had continued to do so for almost an hour and a half before the break. The jury seems very attentive. They're taking a little bit of notes, but not like they did during the trial. They're very much just following along with the PowerPoint presentation that Dan Owens is presenting, understanding what he's saying. A couple of them are nodding as he's talking. And then when he gets into those graphic, grisly details about what this defendant did, some of them will look directly at Kellen Winslow as he's talking. But I have to say, it was a good call for Judge Bowman to call a break when he did, because it seemed like they were getting a little fidgety and a little tired about the tedious, legal talk towards about the hour and a half mark, Julie.
Right, Chanley. I was wondering the same thing, and I had a little Freudian slip there. I misspoke saying open, closing arguments, of course. And it seemed like he came out with such a bang. I'm glad you mentioned that. It seemed like he came out with a bang so strong, and then things were really starting to lose momentum there. Did you notice any different reaction from the members of the jury as you were watching them?
Definitely. It was like a little bit of a deflating as he gets into the complexities, the weeds of some of the elements of these charges. It's hard to sit there for an hour and a half and to take all this in. I'm trying to take notes myself, and it was time for a break. But you were right. We really witnessed a different Dan Owens today that we've seen, I think, throughout the whole trial. He had passion, he had emphasis and clarity as he spoke to the jury, almost relating to them at times. There was that moment where one of the jurors couldn't stop coughing, and the judge asked him if you were okay, and I think Dan handled that really well. He's like, we have these moments of levity, and that's good because we're all human and we're all here, but still, this is a very serious topic. These are serious charges, and we need to do this job seriously. So he handled that really well.
Right. You are right, Chanley. He most certainly did have to hand it to him. I want to ask you briefly, who do you see in the gallery supporting Kellen Winslow II today?
The 2 rows reserved for the family of Kellen Winslow II are full today, Julie. We see, of course, always Senior, his father, is there. His mother is not there today, but we have family, friends, and relatives, some familiar faces we've seen over the last couple of weeks. But the rows are full, and there's a lot of media attention here. There's some general public in the gallery, as well as, just like in opening statements, some of deputy DAs that work in the office of Dan Owens filed in the courtroom to support him as he gives his closing argument.
Very good. Well, we'll let you get back into the courtroom. Thanks so much, Chanley Painter, Court TV legal correspondent, reporting for us. Chanley, thank you. And what we want to do is take a break now here on Court TV Live. We'll take you back into the courtroom to continue watching the closing arguments in this case right after this.
Parts and labor included. When I needed ARW, they were there. My oven actually took a dive in the middle of making a big dinner for family and friends, picked up the phone, called ARW, they repaired it, dinner saved, that easy.
My air conditioning broke on a Sunday. It was so hot. I called ARW and they came out and fixed it right away.
You won't believe what ARW covers. Heating and air conditioning, washers and dryers, kitchen appliances, plumbing, water heaters, electrical systems, even pools and spas, and so much more. All you have to do is call or go to getahomeplan.com. Plus, ARW's partner with Assurion to offer protection for all your new and used household electronics for just one low price.
I dropped my laptop and ARW replaced it with a brand new one, and all I paid was a small service fee.
All plans are fully customizable and come with a 30-day money-back guarantee. Call now and get a home security system valued at $1,250 free with any plan. And you can trust ARW to be there when you need it. Just call ARW and a licensed technician will be dispatched to your home. All covered repairs are guaranteed.
My refrigerator broke, and not only did ARW repair it fast, they even sent me a reimbursement check for all the food that went bad.
So come on, relax. Stop worrying about unexpected breakdowns and costly repairs. Call American Residential Warranty. They'll get you covered.
Call 1-800-713-6687. Again, that's 1-800-713-6687 or log on to getahomeplan.com today.
Oh my gosh, that's Frank Thomas. No. Yes, that's him. Go ahead. Excuse me, are you Frank Thomas?
Yes, I am.
I bet you get recognized a lot.
I was a pretty good ball player.
You were?
Some people thought so.
Sorry, we recognize you from those Nugenix commercials.
Oh, yeah? That's great.
So does Nugenix really work?
Oh, yeah. I really can feel the difference. My workouts are better, and I feel a lot more energetic.
I wish my husband would use Nugenix.
It's so easy to get started. All you have to do is send one simple text.
Text 42424 and enter ALIVE for a complimentary bottle of award-winning Nugenix, the #1 selling free testosterone booster at GNC. Its unique man-boosting formula is powered by Testifant, a patented key ingredient clinically researched to help a man feel stronger, leaner, more energetic, and more passionate.
And you're going to like the difference, too.
Text 42424 and enter ALIVE for a complimentary bottle of Nugenix. Samples are not available in stores. Text 42424 and enter ALIVE.
Deputy District Attorney Dan Owens continues delivering his closing argument. Let's listen back in live.
Mr. Winslow was being monitored by law enforcement, that there was a poll cam monitoring the comings and goings from his residence. And on the 14th, that's when they seized the vehicle and collected the vast majority of the evidence in this case. Now, there was a DNA search done. You had crime scene specialists and you had criminalists, both, who basically tore that car apart, did what they could to at least find what was going to be detectable there. Recall the testimony from Kelly Hensley, the criminalist from the lab. She told you about DNA. She told you about the various forms that it comes in, bodily fluid, potentially blood, potentially semen, right? She talked about sweat. She talked about saliva. Then she talked about touch DNA, right? When you have a leather interior car, you might not be able to get blood from the leather interior, right? When you have the criminalists that are searching for blood, they might not be able to find it. And ladies and gentlemen, you heard the testimony of Jane Doe 1, and she described profuse bleeding, we'll call it that, right? Does that really matter whether there was profuse bleeding or not? Does that really matter to confirm or corroborate what she said when you have the mountain of evidence that I've been discussing now for the last hour and a half? I submit to you, no. It's really not all that different from not being able to have any findings from strangulation, which we know to happen in more than 50% of cases. But what did they find during the DNA search? They found the defendant's semen, a sperm fraction from the defendant, left behind in the back seat of the car. What does that show? It shows that the defendant at least ejaculated at some point in the rear portion of his vehicle along the floorboard, right? We have the defendant who's been accused of sexually violent, forcible crimes. We have the defendant who exposed himself to a neighbor down the street. And we have the defendant who later engages in an act of masturbation in a jacuzzi in public right next to a woman, 77-year-old woman. What does that show? Is that evidence of his propensity, his predisposition, his sexual perversion? And after the well-publicized arraignment of the defendant, Jane Doe 4 came forward. Jane Doe 4 from across the country, a mother of two, a Marine wife. No interest in the outcome of this case other than to get justice. What she thought would be something that might help Jane Doe's 1 and 2, for all she knew. That when she read in a news account that they may try to use his professional football career as an excuse for what he had done to these women, that shocked and offended her and put her right back into that traumatized state that she had worked so hard to get away from. That she too knew what this defendant was capable of. That she too had something taken from her, just like Jane Doe 1 and 2, and that compelled her to come forward. She didn't make it up on June 18th when she reached out to Nikki. And you know that from the other witnesses who testified. Well before Mr. Winslow had been accused of any other sexual offense, Jane Doe 4 had already told her story. Not one, but two, well, not two, but three people. The three people that she would confide in. Best friend, her live-in boyfriend, and her husband. And she didn't make some grandiose statement about all the things that he had done to them, that he had done to her. She just told them the truth. She was 17, she had too many beers, she woke up and he was having sex with her, their face being shoved into the crotch of another man. Rape. I'll talk to you about the elements of rape. Forcible rape can occur even when it begins as a rape of an unconscious person. The rape can be done by force or fear even when it initially started as a rape of an unconscious person. And think about that. When the defendant acted, was the victim consenting to the intercourse for the forcible rape? No, the direct testimony is that she was not, that she did not consent to what he had done. Despite the attempts to imply by Mr. Carlos that, well, maybe you must have done something to make him think that he was allowed to have sex with you, she said no. I have no waking memory. My last memory is being on the couch, and my next memory is being raped from behind, with my face being pushed into the crotch of another man. And that when she came to, she did try to resist. All 5 foot and 95 pounds of her, with the defendant on top of her, grabbing her, thrusting inside of her, she tried to resist, and she pushed back, and she cried out, and said no, and said stop, and he didn't. That's a forcible rape. She was afraid, she was tearful, she was distraught. Ladies and gentlemen, just because she doesn't have any waking memory prior to the force used, the non-consensual act that occurred, that does not mean that he's not guilty of rape. There's no evidence whatsoever that Jane Doe 4 ever consented to rape, that she ever consented to the defendant's forced sex acts. Let's talk about rape of an unconscious woman, because it does have different elements. The act itself is the same, sexual intercourse with the victim, and that the victim and the defendant were not married to each other, again, not in dispute. But here, there's no consent element for rape of an unconscious person. Consent is not an element of rape of an unconscious person. The third element here is that the victim was unable to resist because she was unconscious of the nature of the act. She was not aware of what was happening. She had 3 beers, she was tiny, she was tired, she was feeling buzzed, dazed. She even described how she was splashing water on her face trying to come to as best she could. And while she did that, what does the defendant do? He's banging on the door telling her to hurry up. What was he planning to do? That her last waking memory is being on that couch, and then she's being penetrated from behind by the defendant. She has given you direct evidence that she was unconscious of the nature of the act. Lastly, the last element is that the defendant knew that the victim was unable to resist because she was unconscious of the nature of the act. Right? Of course he knew that she was unable to resist. How did he get her upstairs? How did he get her into that bed? How did he get her face into the crotch of Matt Vaughn? He knew that she was unconscious of what was happening, that she was not aware, knowing, voluntarily acting. A woman is unconscious of the nature of the act if she is unconscious or asleep or not aware that the act is occurring. And that's the evidence that's been provided, and there's been nothing to contest that, right? So then the defendant is guilty of rape of an unconscious woman. He's also guilty of forcible rape of that same woman because when she regained consciousness, she fought back and he continued to rape her. And he turned her and changed the position and raped her further. The defendant is guilty of both crimes against Jane Doe 4. And how do we know that Jane Doe 4 isn't some Johnny-come-lately coming in at the end of things trying to make this all up? Well, you heard the actual evidence of the conversation that took place, and it was caught in real time, because in the digital age, we have a track record of the information that's shared between Jane Doe 4 and Nicole Edwards. And the first thing she says to Jane Doe 4 when she sends her that link to the article that caused her that shock and that harm and that trauma that she had to relive was, never said anything because I thought it was always my fault, as she told you from the witness stand. But I remember screaming, no, I can't, Nikki. This is truly bringing me to tears and freaking me out. What's Nicole's very first response? I do remember. I do remember. This happened, ladies and gentlemen. Nicole Edwards' response to her is independent evidence from the testimony of Jane Doe 4 that shows he's guilty of what he had done. I hated that we never said anything. I'm so glad they finally got him. Jane Doe 4, you have no idea the feelings I'm having right now. Isn't that real? Isn't that true? Isn't that a genuine and honest response to saying that a man who had raped you when you were a teenager in high school, when he rapes again, the feelings that Jane Doe 4 was having right then, the blame she may have felt because he did it again to another woman, that's real. And that hurts. And you saw that play out. And you saw that authentic reaction that she had to come forward because she had information about what he'd done in the past. And then you also heard from Brandon Guillermo and her husband with vague details, but the circumstances under which she told them that a man named Kellen had raped her, had sexually assaulted her, those all make sense too, right? One, she's having nightmares when asleep in bed with her live-in boyfriend, and she awakes, and he's saying, what's wrong, what's wrong? And she tells him. That's nearly a year afterwards. And then years later, with her husband, they're talking about prior experiences, and she tells him, no, I was raped. I was assaulted by a guy named Kellen. Ladies and gentlemen, all of that predated any outside information about other acts by the defendant. And all of that is independent evidence that corroborates Jane Doe number 4. But not only does that corroborate Jane Doe 4, but the identity of the assailant itself is conclusively proven with the photograph that she has. And maybe you thought initially, that's kind of strange. Why would you keep that? Wouldn't you want to get rid of that and purge that from your memory? Well, what else rings true about what she said? I wanted a reminder that even when you feel safe, anyone can hurt you. And it was because of my daughters that I wanted to be able to get justice for these other women, to teach them to speak up when you've been harmed. Now, I told you how other evidence is not required in a sex offense according to the law, right? The testimony of a complaining witness alone is enough. But you also have the other crimes evidence, the predisposition and the propensity. So the fact that this happened with Jane Doe 4, as well as it happening with Jane Does 1, 2, and 3, that's all propensity evidence. It shows that he is inclined and willing to commit these types of offenses. But as it relates to Jane Doe 4, there's a special allegation that the court read to you yesterday. It's going to be contained on the same verdict form. Jane Doe 4, if you find him guilty of the forcible rape and the rape of an unconscious woman, once you've found him guilty of that crime, and you write in guilty on the verdict form, there are 2 special allegations. The first is whether or not there is independent evidence that clearly and convincingly corroborates Jane Doe 4's testimony, right? And that's what I was just referring to. The prior statements to Nicole Edwards, to Brandon Guillermo, and to her husband Troy M., the photograph, and the other acts evidence. Independent evidence is defined as separate and apart from Jane Doe 4's testimony. So all the testimony from the other witnesses and her prior statements and the text messages to Nicole Edwards is separate and apart from her testimony. It may include evidence of the defendant's sexual misconduct against a separate victim. So if you find that he committed the crimes against Jane Doe 2 and Jane Doe 1, or even Jane Doe 3, you can find that that sexual misconduct is independent evidence that he committed the rape of Jane Doe number 4 back in 2003. It's what the law says, and that's what you're allowed to do in order to make sure that justice is had for every one of his victims. Now, it goes further, and it says that such sexual misconduct, if believed by you, may, on its own, standing alone, constitute independent evidence that corroborates the victim's allegation. So if counsel gets up here and they argue to you that, well, you can't really believe everything that Jane Doe 4 said, it's just an allegation. Well, maybe she said it before, but it's the same allegation that she's testifying to. That's not the state of the law. The law says that even the other acts evidence by itself is independent evidence of Jane Doe 4's rape. Clear and convincing evidence, it's a different standard of proof that the judge instructed you on. It's less than beyond a reasonable doubt, and it's more than a preponderant standard, which simply means more likely than not. Ladies and gentlemen, Jane Doe 4's rape has been proven beyond a reasonable doubt, and there is independent evidence that clearly and convincingly corroborates the allegation. All of the other acts, all of the prior statements, the photograph that was provided in the text messages that were read into evidence confirms and corroborates that. That special allegation only applies to Jane Doe 4, all right? But there's an additional allegation that applies to Jane Doe 4 as well as Jane Does 1 and 2. It's an important allegation, and I labeled it the multiple victims allegation. That's the way the instruction reads. If you find the defendant guilty of 2 or more sex offenses, whether they be against Jane Doe 1 or 2 or 4, 2 or more sex offenses, as charging counts 2, 3, 4, 5, or 7. That would be the forcible rape of Jane Doe 1, the forcible oral copulation of Jane Doe 1, the forcible rape of Jane Doe 2, the forcible sodomy of Jane Doe 2, and lastly, the forcible rape of Jane Doe 4. If you find him guilty of 2 or more of those offenses, you must then decide whether we have proven the additional allegation that those crimes were committed against more than one victim in this case. This is the easiest legal instruction you've received. If you find beyond a reasonable doubt that he committed more than one forcible sex crime against more than one victim, then it's true. And you should fill it out accordingly. And then we turn to Jane Doe 5. Jane Doe 5 is a woman who, maybe we all have our favorites in terms of all these people that have come in to testify, but she's a woman that literally had no dog in this fight. She has no interest in the outcome of this case whatsoever. She's not motivated by anything other than coming to court and telling the truth. And what did she tell you time and time again? She didn't want to come forward. Her husband made her. She was afraid. She was trembling. She even said she was petrified by this man. Not a man that she had seen on the news, this man who was doing what he did to her at the gym, who asked her, as he, after stroking his penis right next to her, waiting until she was on an exercise machine right next to him, stroking his penis and pushing it in her direction and asking her, do you see that? Do you like that? Is that not consistent with what he had done with Jane Doe 3 when he removed his penis from his bicycle shorts, standing there erect and holding it and smiling at her? You see that? You like that? That's what this defendant did. That is the extent of his sexual perversion. Lewd conduct in public. Lewd conduct in public can encompass a broad range of actual sexual conduct, right? Did the defendant, according to the first element, willfully engage in the touching of his own genitals? You have 2 separate incidents. You have the one where she unmistakably said he was touching and rubbing, stroking his penis as he sat next to her. And then you have the other incident where he gets into the jacuzzi with nothing on other than a tiny towel that's used to wipe down the equipment, and he sits right down next to her in an 8-person jacuzzi, and he begins moving his arm underneath the water. And as she described, and as you saw, he's masturbating. Yes, there's froth on the water. Yes, there's bubbles. Yes, she didn't actually see his penis. But who would look? And as you'll see, you don't have to see the penis. You don't have to actually see the exposed genitals for him to be guilty of lewd act in public. The defendant did so with the intent to sexually arouse or gratify himself or another person, or to annoy or offend another person. A very similar element to the indecent exposure count with Jane Doe 3. Almost identical. And that's getting into the mind of the sexual deviant, of the person who actually committed the act. What was his intent at the time? Was he trying to sexually arouse himself as he's stroking his penis and gaining an erection? Of course. Was he gratifying himself? Yes. But he was also annoying or offending another person. So he's guilty, according to that element. Was he in a public place? Of course. He's in an open gymnasium. Was someone else who might have been offended, were they present? Jane Doe number 5 described that she was. And did the defendant know, or reasonably should he have known, that another person who might have been offended was present? He sat down right next to her. He waited till she came on the exercise machine, and he began stroking himself. And then he stands in front of her, facing her, locking eyes with her, asking her, do you see this? Do you like that? That's a lewd act in public. When he goes into the jacuzzi, he walks out, the locker room. He gets a drink of water. He looks directly at her. Is she making that up? Is she lying about that? He targets her. He identifies her. He recognizes her. He walks out with his bathing suit in his hand, puts it on top of his backpack, wearing nothing but the towel, and he acts again. Consistent with what he had done before. He knew that she was present, and he knew that she would be offended by it. Elder abuse and elder battery, the additional counts as it relates to Jane Doe number 5. We're almost done. Jane Doe number 5 is a victim of elder abuse. And maybe not in the way that you might think of it or you see it on TV. It's not a theft, it's not physical pain, but she is a victim of elder abuse according to the law. The defendant, the first element, willfully inflicted unjustifiable physical pain or mental suffering on Jane Doe 5. Did the defendant inflict mental suffering on Jane Doe 5? You saw her demeanor in court. You saw how upset and irate and offended and hurt she was. You heard the descriptions from the gym managers. You heard the descriptions from the initial responding officer. She was still trembling. She was still petrified and afraid. That's mental suffering under the law. Was she an elder? Yes, because the law says it's anyone 65 or older and she's 77. When the defendant acted, he knew or reasonably should have known that she was an elder. As I said, you saw her. She's certainly over the age of 65. She's pushing 80. And the defendant still targeted her. Unjustifiable mental suffering is pain or suffering that is not reasonably necessary or is excessive under the circumstances. It's certainly excessive when a woman's just trying to go about her daily routine. 3 days a week, Monday, Wednesday, Friday, same time, every time, right? When this man decides to target her. Not just once, but twice. And that under those circumstances, she should not have been subjected to anything, let alone the mental suffering that he inflicted upon her. Elder battery, similar to elder abuse in the last two elements, but the first element just requires that the defendant touched her in a harmful or offensive manner. Under those circumstances, in that jacuzzi, when he made physical contact by grabbing / touching / what is this when you put your hand around your arm on the elbow, as she said repeatedly, that's a grab, right? When he touched her in that offensive way, right as he had just been masturbating next to her, that's a battery. The slightest touching can be enough to commit a battery if it's done in a rude or angry way. Oh, certainly it's been done rudely. Making contact with another person is enough in itself. The touching does not have to cause pain or injury of any kind. So, Jane Doe number 5 is the defendant's last, most recent victim. She's a victim of multiple lewd acts, elder abuse, and elder battery. And there's been no evidence to dispute that. So you have to be asking yourself, God, what are they going to say? What's their theory of the case? How are they going to be able to overcome what happened here? All of this information, all of these women. And really, it comes down to this. Well, you can't believe all 5 of them, right? The presumption of innocence attaches, it exists, all the way through into your deliberations. But once you've all gotten together, decided the facts, and applied the law, you can overcome that presumption of innocence by the mountain of evidence that's been presented. It's not 1, it's not 2, but 3 women who've been raped. 5 women who were victimized by this man. But they would ask you to not believe any of them, or let alone all of them. Do you think that this was no strings attached consensual sex? There's no such evidence that's been presented to you to suggest that, to support that. But they're going to try to ask you to use the presumption of innocence to somehow poke holes, right? But when they try to poke those holes, none of it actually impacts the core facts of what happened. The peripheral, extraneous, things that the law instructs you that you get to decide whether they're important or not. So reject that argument. Who's heard the phrase of buyer's remorse? Is that what this is? Well, you know, I was interested in him at the beginning of the night, and then the next night I had that feeling of maybe I shouldn't have done what I did. There's no evidence whatsoever that that's what happened. Each one of these victims has said consistently that they were threatened, that they were afraid, that they were going to be killed. Jane Doe's 1 and 2. Jane Doe 4, that when she regained consciousness, he was forcibly raping her. Jane Doe 3, she didn't know who had done this, but she was certainly upset and offended by it. And Jane Doe 5, again, didn't know until she and her husband got together afterwards, and in a conversation with the managers, they figured it out. But before that, she had no idea who had done this. Just a man who targeted her while she was at the gym. There is no motive that's been established for any one of these victims. Even when they have made that lame attempt to call back Summer Foster, you say, well, did you create a GoFundMe account? Is this the one that you created? Yes. Did you ask for $50,000? Yes. Why? Notice they didn't ask that. I needed to help my mother. I wanted her to be able to get away from where this had happened to her, to get away from the man that raped her. Ladies and gentlemen, there's been no motive established. Notice also that not a single shred of evidence suggests that any one of these women is after the defendant for his money. There's been no evidence presented about that because it's not true. Ladies and gentlemen, reject these defense theories. What is their theory on Jane Doe 3? It wasn't me. In opening statement, Mr. Watkins stood up and said, Jane Doe 3 is not going to accuse Mr. Winslow of anything. She doesn't have to. We've proven that it was him. We've proven that he did this. We've proven that he was there that day. Ladies and gentlemen, what's the theory that they have? Jane Doe 4, to go through the hell that she did by coming forward and talking about what he'd done. What motivates her? Are they going to argue that because she consented 2 weeks prior to sex, that means that she had to have consented the second time? How does that make sense when she described that the first consensual act where they were kissing, they were being amorous, they had been flirtatious earlier, that ended abruptly when she put a stop to things? When the same person, Matt, came into the room and she stopped Mr. Winslow. Was she going to consent the next time when Matt was in the room? When perhaps even others were filming it? Was she going to consent? That's what they'd like you to believe, but that's not what's been proven through the course of the evidence. There's no evidence to support that theory. She has told you that she stopped things the first time, and she told you that she did not consent the second time. So that's what it amounts to, right? They must all be liars. Every single one of them. Every woman that you listened to over the last 2 weeks, they must be lying to you, and they must be incredible actresses as well. Can't believe anything that they've said. Or at least maybe not some of these things on the periphery, so then you shouldn't believe any of the other stuff, right? Come on, ladies and gentlemen, use your common sense. Reject that theory because it's unreasonable. It is completely unreasonable to believe that every single one of these women has come to court and gone through what they've gone through to tell their story for a lie. And how do they possibly explain Jane Doe 5? They're going to call her a liar? Or maybe she was just so mistaken about what he was doing when he thrust his erect penis in her face saying, do you see that? Do you like that? It was just a huge misunderstanding, right? This case is not a he said, she said. Reject that theory too. How could this case possibly be a he said, she said? This case is a she said, and she said, and she said, and she said, and she said. 5 separate women, 5 separate victims, all of whom have been confirmed and corroborated by each other. This man is a sexual predator who acted and victimized against every single one of these women. You as jurors have a duty to reject the defense theories because they're unreasonable. You have a duty to render true and just verdicts based upon the reasonable assessment of the evidence. The court told you that direct evidence can prove a fact by itself. The testimony of a witness is direct evidence. Circumstantial evidence is evidence of another fact from which you may logically and reasonably conclude the truth of the fact in question. All of the other acts is circumstantial evidence that corroborates and confirms the truth of what the direct testimony was from each victim. Both are acceptable and reliable to prove elements of a charge. And the court instructed you, when considering circumstantial evidence, you must accept only reasonable conclusions and reject any that are unreasonable. And that's why you have the duty to be reasonable and the duty to reject the defense theories, because they are unreasonable. Every single one of counts 1 through 12, the charges, have been proven beyond a reasonable doubt. You, every single one of you, have the awesome authority and privilege to be able to render a guilty verdict and give justice to Jane Doe 1, Jane Doe 3, and Jane Doe 5, to show that they were victims of the crimes that are alleged related to each of them. Give justice to Jane Doe 1 and 2. The evidence is proven beyond a reasonable doubt that he committed both of these forcible rapes against each of these women. That he kidnapped Jane Doe 1 in order to commit rape and oral copulation. That she withdrew her consent, that he threatened her. Find him guilty of all of those crimes for Jane Does 1 and 2. And lastly, give Jane Doe 4 justice. It may be delayed, but give her justice because the evidence has proven beyond a reasonable doubt that he raped her in 2003. Thank you, Your Honor.
All right, thank you. Mr. Carlos?
An hour at least, you think? That's up to the, I guess, the jury.
You want to start now and break it up? So you do.
I don't want to break up, so I'd rather.
I'm sorry?
I don't want to break anything up. I'd rather go straight.
You want to go straight through for an hour? Okay. Do you want to break for lunch now and come back at 1? Or do you want to go straight through to 12:30? I see no hands being raised. So why don't we do this? Why don't we go ahead and take our break now? We will come back at 1. And we'll start up at 1 o'clock and you can go straight through. How's that, Mr. Carlos?
It's fine, man. It's up to the jury, Your Honor. I can do either.
Okay. Well, we sat through an hour and a half, so why don't we go ahead and do that? Mr. Owens, you know how long your rebuttal will be?
Depends on how long this goes.
Okay. So we'll go ahead and do that. We'll go ahead and take our break now. So we'll come back early. We'll come back at 1 o'clock. And we'll see everybody back here at 1. Please remember the admonition. Don't discuss the case with anybody or form or express any opinions. We'll see you back here at 1 o'clock.
All right, so it's 11:22 Pacific time. They're going to come back at 1 o'clock their time. That would be 4 p.m. Eastern time here. So what we're going to do right now, I believe, is do some legal analysis for you on what we saw in the closing argument delivered by Deputy District Attorney Dan Owens. Very powerful start to that closing argument. The defense will have their chance next. So I'm going to bring in our special guest here in the studio, criminal defense attorney Michael Bixon. Michael, always great to have you here. We got to talk a little bit about what we saw before there was a break in the action because it was getting long. The judge wanted to give the jury a break. Talk to me about your thoughts on how he finished.
You know, we said before, it was a very strong, it was a very bold opening, and then it sort of went downhill a little bit. Right. And I thought after the break, it might pick back up a little bit. I don't think it did. Honestly, I was dying a little bit towards the end there. It was very slow. In the ending, I just didn't really feel any impact. I just almost didn't even notice when he ended. You know, the beginning was great. Middle, it sort of tapered off, but I feel like it just went even more downhill towards the end, honestly.
Sure. And I want to get your thoughts, please. Do you think that he has the evidence that he has proven this case beyond a reasonable doubt?
I do. And again, there's so much here. There's so many different crimes that have been alleged, and there's so many different victims and evidence. I do think that he has the evidence that he needs to secure a conviction. I was a little bit surprised by how during the closing, he kept hitting on that jury instruction in talking about how he only needs part of it and how he can use parts of this to prove the other elements and vice versa and back and forth, it almost made it seem like his case wasn't as strong because he had to rely on the different victims to prove each one other than just having them prove each case independently. So I think it actually hurt him a little bit there.
So you think it kind of took away from the strength that he has in the evidence that he has, or the state has, I should say.
Oh yeah, definitely.
Okay. And as far as, we talked a little bit off camera, you and I were watching it very closely, and it seemed to me like the first part of it was more of a story, very impactful. He used language that really was powerful, words like brazen, callous, despicable, sick, depraved. I mean, he used such powerful words and delivered that with so much emphasis. And then it almost turned into what we were saying seemed more like a lecture where he was teaching. And it's great to arm the jury with the tools they need to deliver the verdict. As an advocate, you want to do that. But do you feel like it was a little lackluster in that it got bogged down with details?
I mean, honestly, it did feel like a law lecture. And while, the jurors do need to hear the law and they do need to hear how the facts apply to the law, you can't let them fall asleep.
Sure.
And it dragged on so much. And, he was repetitive. He hit on, the law, which is great, but he did it for every single one over and over and over. And, it's hard to listen to that repetitively.
Sure.
I think it was hard for the jurors as well.
Sure. Perhaps they could have been tied in a little more, the story and then with the law and the facts, marry them together and hopefully have an effective closing argument. Well, Mike, we want you to stay with us, please, here in the studio. Thank you for sharing your thoughts on that. We need to take a quick break here on Court TV Live. Court is in recess. We're back with much more for you right after this.
The sun used to make our outdoor patio space so hot and uncomfortable, we couldn't even use it.
Then we discovered the Sunsetter retractable awning. Our Sunsetter opens and closes in under 60 seconds. It keeps our patio about 20 degrees cooler.
It provides instant shade and instant protection from the sun's harmful rays.
And Sunsetters start at under $800.
But you can get your Sunsetter for as little as $599 when you call now to get this special $200 discount certificate.
We love our Sunsetter retractable awning, and you're going to love yours too. It transforms your outdoors from sweltering sun to shady oasis in just seconds.
Call now for this free awning idea kit, packed with great awning solutions that will let you enjoy your deck or patio much more often this summer. Plus, get this $200 discount certificate that will bring you your Sunsetter for as little as $599.
But this is a limited time offer. Call now.
Sunsetter retractable awnings are assembled in America, and they're guaranteed to last for years. And talk about options. Choose from manual models or motorized for push-button ease with beautiful fabrics to fit every home. You can even add lights for nighttime enjoyment.
No wonder Sunsetter is America's best-selling awning.
Call now to get the whole Sunsetter story. You'll get this free awning idea kit with DVD plus a $200 discount certificate, and there's no obligation.
Hundreds of thousands of families own and love their Sunsetter retractable awning. We're one of them, and you should be too.
Stay cooler and enjoy your deck or patio much more often.
And do it all at $200 off if you call now.
Call now for your free awning idea kit with local dealer info and $200 discount certificate. Life is better under a Sunsetter. Call now and save. Call 1-800-641-9678. 1-800-641-9678.
Mesothelioma. It's all we do. With 9 offices across the country, we are large enough to take on big corporations. There is no risk. Let us come meet with you.
We only take mesothelioma claims. Call us at 1-800-500-5914 or go to mesobook.com.
Our experience and the size of our law firm makes a difference. Call us at 1-800-500-5914 or visit mesobook.com.
How could this case possibly be a he said, she said? This case is a she said, and she said, and she said, and she said, and she said. 5 separate women, 5 separate victims, all of whom have been confirmed and corroborated by each other. This man is a sexual predator who acted and victimized against every single one of these women.
That was just some of the closing argument delivered by Deputy District Attorney Dan Owens in the case of the state of California versus former NFL star Kellen Winslow II. The prosecutor saying that this is sick, it is depraved, it is callous, and it is this defendant in court talking about Kellen Winslow II being a sexual predator. He tied it back to what he delivered in the opening statement he gave in this case, where he said the defendant took what he wanted. And then today he told the members of the jury, now you know what he's gotten. The court is in recess right now. They're on a lunch break until 1 o'clock their time. That's a Pacific time. That would be 4 p.m. Eastern time where we are. What I want to do while we're waiting for the jury to come back is bring in criminal defense attorney Michael Bixon for some more legal analysis and discussion on what we saw. If we can start with the discussion, please. I'm sure our wonderful viewers at home are thinking the same thing that I was, and many of us here at Court TV are. Looking at Kellen Winslow II today, the first time I saw him, I thought it was video that we might have been replaying from yesterday. Then I realized, no, this is live. He has on the exact same suit and tie as he did yesterday. What optics do you think? You're a defense attorney. Obviously, appearance is important before the jury. Do you think that's strategic? I mean, we know he made $40 million in the NFL.
So he's still in custody. You know, I don't know whether or not they only brought a certain number of suits over for him to wear, because they're supposed to bring it over or have the jailers have them ready for him.
Right.
You know, whether or not it's due to his lack of funds, I have no idea. A big part of what you make when if you're in the NFL or some other, you know, star-like role, a large portion of that obviously goes to taxes and your, you know, representatives, and so you don't always end up necessarily with what you started with. And it's been a while since he played as well. So how much of that money is left, you know, who knows, especially after paying for his defense team, which I'm sure was very expensive. You know, whether or not that contributed to the reason why he didn't have a different article of clothing today, who knows. But it could have been just something as simple as, you know, they forgot to bring a new suit.
Maybe they forgot. I just kept thinking, I wonder if this is strategic. I wonder if he's trying to do something or send some message. I don't know.
Yeah,
but
I mean, it's hard to say. It did look weird, though, that he had the same thing on.
Right. I really did think it was yesterday's video. I really did, until I realized, no, wait, that's him again today with the same tie. And he seems to be looking a little more confident than he did yesterday to me. I want to get your thoughts, Michael. Yesterday, we were all commenting on how he just didn't look well. He looked very concerned. Many times he was seen breathing very heavily. His chest was raising. He would appear hunched over in his chair at times, his brow raised and looking concerned, even pursing his lips a couple times. Today, not much reaction. Your thoughts?
I think it's hard for anyone, you know, especially if you're charged with such serious crimes, to sit there and not have any strong, you know, emotions or reactions, no matter how innocent or how guilty you are. As a lawyer, it's hard to sort of counsel your client and let them know, you know, you're going to be facing some really difficult things throughout this trial, and it's hard not to react, but you have to do your best not to, I mean, definitely any strong outbursts or anything like that, but even these small little facial twitches, you know, whether you're yawning, sighing, leaning back too much, every little thing you do matters to the jurors because they are watching you throughout the trial.
Right.
Today, he did look a lot more strong, though, I can tell you that.
I'm glad you agree. Yeah, just watching him carefully, not much reaction, appears very confident. I'm curious if there were any exchanges between him and anyone supporting him in the gallery, and I'll definitely be sure to ask our legal correspondent, Shanley Painter, that when we have her. Of course, she's in the courtroom watching everything closely, watching the jury. I just want to ask your thoughts on, with juries, I really feel like you never know what they're going to do. And as an advocate, do you feel that way when you're delivering your closing argument, your opening statement, whatever the case may be? Sometimes they may be nodding in agreement with you, you think they're with you, and then all of a sudden you get a verdict you didn't expect?
Juries are always a roll of the dice. You never know what you're going to get. And no matter how, you know, the best thing you can do as an attorney is to educate them on what to expect with the trial, on the law, and the facts, but you know, you can only do so much, and you never know how those dice are going to roll in the end.
You're right, Michael. Let's take a look back together, and with everyone at home, please, at another clip from this morning's closing argument delivered by Deputy District Attorney Dan Owens.
We know that it was him. We know that the sex act occurred. We know where it occurred. So why is she being cross-examined at length about whether it was a Jeep or if she saw a Jeep emblem? We have surveillance video from his own surveillance system that shows him leaving in his black H2 Hummer. Ladies and gentlemen, that's where it happened. Where else could it have happened?
And when he said was being cross-examined, he's referencing Jane Doe number 2 in this case, who testified to forcible rape in the Hummer that Kellen Winslow II was allegedly driving and picked her up and on that date in question. Michael, I want to ask you about something that the prosecutor made a point to point out. He made a point twice during his closing argument to say how the defense team put forth that issue of consent, but we saw no evidence of consent put forth in this trial. Important for the jury to understand because opening statements and closing arguments are not evidence they can consider. I want to get your thoughts. Was that a mistake by the defense team to go ahead and say that in the open, but not have Kellen Winslow II take the stand and testify to that, or call other witnesses who may be able to shed some light on that?
I think they're going to have a hard time trying to bring in other, witnesses to talk about the consent issue. As far as putting Winslow on the stand, I definitely understand why they wouldn't. Whenever you make that decision to actually put your client on the stand, it is a very tricky position to be in, because while you can get out what you want out of them, and you certainly can prepare them as much as you can, at the same time you open them to the possibility of being attacked by the prosecution. And in a case like this, you definitely don't want to do that. I think the prosecutor would have torn him apart if he was put on that stand.
Michael, I appreciate that. Let's take a look back at another clip from the opening statement this morning, and then we'll discuss together.
You heard from the fresh complaint witnesses, or what's also called outcry witnesses. You heard from the spouses. You heard from gym employees. You heard from the deputies. You heard from the detectives. You heard from Nicole Edwards, Brandon Guillermo, Troy M. This is the anatomy of a sex crimes case. That's how these cases are proven. You have the victim's testimony that's then confirmed and corroborated by the prior statements that they've made, the physical evidence that gets collected, and circumstantially supporting and corroborating what they've told you.
This prosecutor is very methodical. He was methodical in his open, he was methodical in his close today. I mean, it seems like he even said to the jury, essentially said, don't get bored. Know that these are building blocks I'm giving you the tools to arrive at a guilty verdict, is what he was saying. I want to ask you your thoughts in particular. In the clip we saw about the anatomy of a sex crimes case, this is a prosecutor who's very experienced. This is what he does and has done for years. He has a great reputation, according to all the guests we've interviewed, really knows his stuff, knows how to put them together. Thoughts on, did he put that together, painting an accurate picture for the jury to allow them to understand why all those other witnesses were called? Even though he was clear that with the law in California, you can hear from a victim alone, or an alleged victim alone, I should say, and that could be enough to convict. But yet he was saying, we're putting forth much more than that for you. Your thoughts, please, Michael.
I think it was important for him to point out just how, the depth of their case and how far it went. It wasn't just, one person taking the stand, and obviously they're sitting throughout this whole trial and they've seen it, but I think to wrap it up and conclude and remind them that it's not just the victim testifying, it's all these other people that are helping to support them, and not just their friends or the family, but also the investigators who help, actually support their testimony.
Right. And we know we use terms like fresh complaint witness, outcry witness. We know what that means. Those of all of you at home who follow these cases closely, you hear those terms, but that might be a little bit foreign to someone sitting on a jury who maybe isn't interested in criminal law and has never heard a criminal case before. I wondered if that was a little too much legalese speak. I think to kind of break it down and say we're talking about her friend Nicole, who is what is called an outcry witness. When you go to that person immediately after you've experienced a crime and you tell them what occurred, do you feel like he connected those dots effectively?
To an extent, I think that if he had made it a little bit more informal, a little bit more casual, it would have been easier to relate to for the jurors. I think that he did use a little bit too many of the sort of the terms of art that we're used to, and it can confuse them a little bit, but overall, I think they got the message that he was trying to deliver.
Michael, I want to take a look at a soundbite, if we can, please. This was when he's talking about the number of complainants in this case, and then we'll discuss, because I know you've had issue with these cases all being tried together, so we'll talk about that. Let's look.
Your duty as a juror is to decide the facts that have been proven and to follow the law. Once you decide the facts, using your common sense, your good judgment as members of the community, your life experience in knowing that lightning certainly doesn't strike twice, let alone 5 times. And you join together in one voice after reviewing all of the facts, after following the law that's been provided to you by the court, and you have one job to do. You have a privilege and you have a responsibility as members of the community to find this defendant guilty, because that's what's been proven.
That was powerful. That's a moment. Lightning doesn't strike twice, let alone 5 times, talking about these 5 alleged victims. I know you and I discussed a few times with this case, you've been with us, following it from the start, about how this is unusual that all 5 of these crimes are being tried in the same trial. Your thoughts about being able to use that in a close? Pretty powerful stuff. It's a lot of ammunition.
I mean, it's very overwhelming to hear about just the number of victims and the number of instances and the amount of evidence that you're dealing with here. I think, I've said from the beginning, it's going to be very overwhelming for the jurors, and it's going to be hard to get around for the defense. On the flip side, for the defense, the prosecutors have to show that, they have to prove beyond a reasonable doubt for every single victim. So if you're not able to do it for 1 or maybe 2, it starts eating away at that case. And because they have all the victims together in one case, they sort of do have all their eggs in one basket, and they have a lot to risk here.
And you were saying you think this could be problematic for them, maybe an issue for appeal?
I agree, yeah. I mean, from the beginning, I never thought this case should have been tried the way it is. These victims are not similarly situated. 1 and 2 are very similar. 3 and 5 are sort of similar, and 4 really is separate. I think there should have been 3 trials, and I think for the prosecutors, they would have had more chances for a conviction as well. When they have to start relying on weaker cases to bolster the stronger cases to bolster the weaker cases, I think it does eat away at their arguments a little bit, and I think they've had to do that in this case.
Would you say with Jane Doe number 1's allegations, would you say that she is the weakest link, so to speak,
Absolutely.
in the chain of all 5?
I think she had the most inconsistencies. I think that there were the most lies given, and whether or not those were, I guess, for the jurors to decide that, just because she was lying about certain facts, does that mean that she lied about the whole incidents? It's hard to say, but I do think it definitely hurt her.
Right. I loved the moment where Dan Owens said that it was Kellen Winslow II who put Jane Doe number 1 on the stand. Yeah. It was like he was acknowledging there were lots of weaknesses with her testimony, her personal situation. If we can, let's take a look at a clip now together referencing her problem with alcohol.
You know that she's private, you know that she's proud, and you know that she tried to hide the fact she's been battling alcoholism for 30 years from you. As her daughter said, she lied about her alcoholism. It's for you to judge whether or not that matters to you when she's describing to you what he did, when he threatened to kill her and forced her to drive to that backside of the shopping center where he raped her.
I thought that was very smart of him to concede that she was untruthful about that for reasons that would be understandable, battling an addiction. I want to get your thoughts. Do you think he really scored some points there with the jury?
I do, but the issue that I think he has is that wasn't the only inconsistency with her, statements. There were multiple throughout there, her walking the streets, her criminal history, I believe, the way that she actually described the whole assault, I thought there was something missing from there. What exactly it was, we're not too sure. But I think there are a lot of inconsistencies throughout her statements.
Do you think it could be enough for an acquittal with respect to her charges?
Maybe, but again, obviously, even if they get past 1, they still have to do with 2, 3, 4, and 5, and that is a lot to deal with.
Right. Now, this is a case, we have 12 crimes that are charged here, 5 alleged victims. Of the 5, was there one who stood out to you as possibly being the strongest witness in terms of testimony given?
So I think 4, possibly, and it depends on which version of the story that you're following, because there was 2 different versions of the story. One is where she was in a house, one is where she's in a car. I was surprised that Mr. Owens didn't really address the different stories that were presented, and while Jane Doe number 4 basically contests that no, it was just that one version that she gave, and she doesn't know where that other version came from. It's still out there, and the jurors have heard it. How much they believe it, I don't know. But I think if they were to believe version number 1, which she presented, it's very strong.
Right. I appreciate you making that point, Michael, because you're right. He was very thorough. This prosecutor, extremely thorough, and I'm perhaps even too thorough at times, maybe losing the jury with some of the detail that was gone over and over again. But he didn't mention that. Maybe not to remind them of the defense's version of events, which they'll be sure to bring up when they have their chance to close.